The hearings in the matter of case number CFI 77-2021 before His Excellency Justice Nasser al-Nasser. The claimant is represented by EKP Legal and the lead counsel is William Bramble. The defendants are represented by Mohammed al-Ninjawi Advocates and Legal Consultants, and the lead counsel is Ziad Ahmed Goma. Thank you very much.
Thank you, Hamid. I think we shall start with the defendant, yeah? Since the defendant is the one requested the hearing. Mr. Ziad.
Yes, sir. The beginning, the defendants would like to thank the court for scheduling today's hearing to hear the parties' oral submissions. The issue in hand today is very important. It's about fairness, equal opportunities among the dispute parties, transparency, and acting in good faith. The claimant's application for extension of time may appear innocent when looked at in isolation. However, it is the defendant's position that it's not. The claimant's application for extension of time has indeed several serious consequences in these proceedings. Looking back at how this all started, and based on the defendant's suggestion, the parties of this case agreed during the CMC hearing that they would attempt to reach an agreement on two joint experts to opine on their claim, one in accountancy and the other in property. It was also agreed that in case of being unable to reach an agreement on these appointments before a specific deadline, each party would appoint its own experts. And following several discussions between the parties, the CMC order was issued with paragraph 11 setting out the deadline for the parties' agreement on the appointment of the joint experts to be 7th of November 2022. Then paragraph 15 of the CMC order provided that if party-appointed experts are engaged, then the parties shall file and serve their expert reports, if any, no later than 4 p.m. on 5th of January 2023, and supplemental expert reports, if any, shall be filed and served no later than 4 p.m. on the 2nd of February 2023. This is Exhibit D1. By 11 November, none of the experts that the parties had contacted were appointed. So the defendants informed the claimant by email that they would seek party-appointed experts pursuant to the CMC order. This was followed at a later stage by the defendant's decision that they would not need the appointment of a property expert. So in December 2022, so they immediately informed the claimant of their intention not to appoint a property expert. And then in December 22, the claimant informed the defendants that it wouldn't also be appointing a property expert. The defendants then filed and served their accounting expert report on 5th of January 2023, pursuant to paragraph 15 of the CMC order. They were then taken by surprise when the claimant sent them that evening an email informing them of its decision not to file its own expert report, and that it might instead file and serve a responsive expert report on the agreed date for filing and serving the supplementary reports. The defendants would like to highlight here the fact that the claimant never, before 5th of January 2023, which is the date of submitting the original reports, communicated to the defendants its intention not to file and serve an accounting expert report, nor its intention to file and serve a responsive one on the date of filing and serving the supplementary reports. The claimant, in fact, waited until well after the defendant's filing and service of its expert evidence, and then made this surprising announcement. The defendant objected to all of this in several occasions, as shown in the skeleton arguments and the exhibits, which will not be repeated here so not to waste the time of the court. This was followed by the claimant filing of its application, the claimant's application requesting an extension of time to extend the date that was originally designated in the CMC order for both parties' supplementary reports, to submit their expert report along with a new property expert evidence. The court then issued its order dated 2nd of February 2023, granting the claimant the extension it sought up to 9th of February 2023, without dealing with the defendant's repeated requests to deal with the matter at a hearing. Based on that order, the claimant filed a responsive joint expert report, inclusive of new property expert evidence on 9th of February 2023. The defendants could not file their own supplementary report on either the original or the extended date, since there was no report submitted by the claimant on the 5th of January 2023 to respond to in the first place. So the questions before the court today are whether the claimant deliberately breached the directions of the CMC order by failing to file their accounting expert report on the designated date, failing to notify the defendants and the court that it wouldn't be filing its accounting expert report on the designated date, introducing new property expert evidence in breach of the parties' agreement, failing to seek the defendant's agreement to introduce new property expert evidence contrary to the previous agreement, failing to seek the court's permission to introduce new property expert evidence. Also, whether granting the claimant's application for an extension of time resulted in procedural irregularity and unfairness to the defendants, and whether the claimant provided sufficient justification, or any, for filing new property expert evidence at the time of filing the supplementary reports. And finally, whether the claimant should be sanctioned under Article 26.82 of the court rules for deliberately breaching the directions of the CMC order by not being permitted to rely on the expert evidence they now seek to rely upon. So first, as to whether the claimant's conduct constitute a breach of the CMC order directions. Paragraph 15 of the case management order grants the parties the right to engage party-appointed experts to opine on their claims. The experts' reports were ought to be filed and served no later than 4 p.m. on the 5th of January 2023. The same paragraph further allowed the parties to file and serve supplementary experts' reports no later than 4 p.m. on the 2nd of February 2023. The defendants filed and served their accounting expert reports on the 5th of January, pursuant to paragraph 15, to be surprised thereafter by the claimant's decision not to file and serve its expert report, and its notion that it may file and serve a responsive expert report on the date of filing and serving the supplementary reports. The claimant never communicated to the defendant its intention not to file and serve an accounting expert report, nor its intention to file and serve a responsive one on the date designated for filing and serving the supplementary reports. The claimant also never sought the defendant's agreement on any consent order changing the agreed timetable for the procedures. The claimants never sought the court's permission to allow it to file a responsive report and or new property expert evidence. The claimant deliberately chose not to engage an expert during the designated time, and accordingly, as the defendant's current position, the claimant waived its right to appoint one in these proceedings. The claimant further intentionally ignored to notify the defendants and the court of its intention not to file any expert evidence on the 5th of January. It further unilaterally decided to change the entire procedural steps provided in paragraph 15 of the CMC order, as it decided not to file its original report on the designated date, just to be able to examine the defendant's evidence firsthand, then file its original expert report well after the date of filing the supplementary expert reports, instead of the agreed simultaneous filing of the original and supplementary reports, as shown in the CMC order. This is while taking away the defendant's opportunity to file their own supplementary reports on the designated date. Therefore, it's the defendant's position that the claimant should not be rewarded for deliberately breaching the CMC order at the expense of the defendants who followed the CMC order in good faith. As to the second question, as to whether the claimant's application for an extension of time results in serious procedural irregularity and unfairness to the defendants. From the evidence that were attached to the skeleton arguments, the court will be able to see that the claimant has been constructing its own alternative process that conveniently suit only the claimant and which very well has nothing to do with the agreed timetable or the provisions of the CMC order. This alternative process is designed to give advantage to the claimant and prejudice the defendant's positions. The court will see that the claimant has benefited from breaching the CMC order, as it now had the advantage of looking into the defendant's expert evidence and then filed an original expert evidence designed to respond to the defendant's expert evidence contrary to the directions of the CMC orders, that the filing of such evidence would be only simultaneous. This unwarranted conduct took away the defendant's equal opportunity in examining the claimant's expert evidence and prepare original expert evidence in response to it. The claimant's request for extension of time to file an original joint expert report after the date designated for the supplementary reports further takes away the defendant's opportunity to submit a supplementary report responding to the claimant's expert report on the date designated for such procedural step. This is all due to the claimant's failure to file this original report on the 5th of January 2023. Accordingly, the request for the extension of time puts the defendants on the back foot, and if granted, will constitute unfair treatment to them, as they would be unreasonably deprived from the right to file a supplementary report in response to the claimant's original expert evidence, and in the agreed and ordered simultaneous manner. This is despite the fact that the defendants are the party that indeed followed the CMC order by filing their expert evidence on time on the 5th of January. And even though it is now established that the parties agreed back in December 22 that they wouldn't file property expert reports, the claimant still surprised the defendants with filing a new property expert evidence, which is an original expert evidence, on the extended date of the filing of the supplementary report. It is the claimant's unjustified failure to file its original expert evidence on 5th of January 2023 and its failure to follow the directions provided under the CMC order that resulted in all of these procedural irregularities that are certainly impacting the integrity of the entire proceedings. For these reasons, the claimant should not, again, be rewarded for deliberately breaching the CMC order, especially at the expense of the defendants who followed the CMC order in good faith. And the defendants would like to give an example as to the importance of the simultaneous filing of evidence in these proceedings and the ironic behavior of the claimant in dealing with the defendants in these proceedings. So during the preparation of the skeleton arguments for this hearing, the claimant sent the defendants 5 emails asking for their confirmation of the simultaneous time of filing the skeleton arguments. The claimant further contacted the defendant's legal representative to make sure that the filing of the skeleton arguments is done at the same time. The skeleton arguments were filed at the end, and based on the claimant's suggestion, while both parties' representatives were on the phone together sending them out. This is, of course, because the claimant wanted to make sure that the defendants do not get to have a look at the arguments first and address them in their own skeleton arguments. This is while bearing in mind that this is a side proceedings that cannot be compared in weight to the expert evidence and its importance in the main proceedings. This shows 2 things. The first is the significance of the simultaneous filing of evidence in ensuring that one party does not get to have a first look at the party's evidence and response to it. The second is the claimant's hypocrisy in insisting on the defendant's simultaneous filing of documents when it serves its interest, while totally ignoring it when it doesn't. As to whether the claimant's request for extension of time is related to a supplementary report in the first place. As evident in paragraph 15 of the CMC order, the date 5th of January 2023 was designated for the simultaneous filing of the parties' original expert reports. Meanwhile, the date 2nd of February 2023 was designated for both parties' simultaneous filing of supplementary expert reports, which means that the parties had to submit them at the same time. The term supplementary naturally suggests that it's something additional or complementary. While the defendants accept that a supplementary report could be responsive in nature, however, it can only be a continuation to an existing original report, but it cannot be an original report in itself. It is evident from the provisions of the CMC order that the consecutive filing of original responsive expert report was never planned as part of these proceedings. In this case, the claimant did not file its original report on the designated date, and it has not, to this moment, provided any excuse or justification for the breach of the directions of the CMC order in terms of the date of filing that report. Since the claimant filed its joint report for the first time on the 9th of February 2023, this report can only be characterized as an original report, not a supplementary one, as alleged. As to the question of the validity of the claimant's request for extension of time, the claimant applied for extending the time designated in the CMC order for the filing of the party supplementary reports. The claimant then filed on 9th of February 2023 an original responsive accountancy expert report along with a new property expert evidence. None of these expert evidence can be described as supplementary reports within the meaning of paragraph 15 of the CMC order. Now, since the claimant's application is made for an extension of time for the filing of a responsive report and the new property expert evidence, and whereas the claimant never filed any original accountancy or property expert report on the designated time, it is clear that the claimant's request is in fact made to extend the time of a non-existing procedural step in either the CMC order or the procedural timetable. The claimant instead should have applied for a permission to file a new original expert evidence along with the justifications and the reasons for its failure to file them on the designated date in the first place, which has never happened. Accordingly, the claimant cannot be granted an extension of time to a non-existing procedural step, which renders this application invalid. Now, for the fifth question, whether there is a justification for the defendants to introduce new property expert evidence in these proceedings. The claimant's request for extension of time for the filing of a joint expert report, inclusive of a new property expert evidence, they contend that this is in response to the defendant's accounting expert commentary on the claimant's claim for loss of rental income. This contention is incorrect. The defendant's accounting expert only looked at the numbers provided by the claimant during the pleadings process and opined on them from a strict accounting point of view. The accounting experts only examined the numbers without opining, without giving an opinion on, as a property expert. They never provided a market analysis, property market analysis. This means that there is no new evidence introduced by the defendants in that case that requires the introduction of a property expert opinion. The defendants further reiterates that the claimant bears the burden of proving its own claim. The claimant willfully chose not to file any original property expert report to support its unsubstantiated claim for the rental loss. The claimant further confirmed to the defendants in December that it would not be engaging a property expert in these proceedings. And the claimant had sufficient opportunity to file this property expert report or even the accounting expert report on the original date, which was the 5th of January. Yet it chose not to do that. Therefore, the claimant's contention that it needed a property expert opinion to respond to the defendant's accounting expert report is only contributing to the procedural irregularity created by the claimant itself when it chose not to provide any expert evidence when it had the sufficient opportunity to do so. The last question is whether the claimant should be sanctioned under Article 26.82 of the court rules for deliberately breaching the directions of the CMC order. It is now clear that the claimant had deliberately and unjustifiably breached and undermined the directions of the CMC order, causing several procedural irregularities and unfairness to the defendants by depriving them from their equal opportunity to file original and supplementary reports on the designated dates in a simultaneous manner, as directed. Whereas Article 26.82 of the DIC Court Rules provides that where a party fails to comply with the direction given by the court, any other party may apply for an order that he must do so for a sanction to be imposed or both of these. Article 26.83 further reads, the party entitled to apply for such an order must do so without delay, but first warn the other party of his intention to do so. And now this is the tricky part. The defendants notified the claimant on the 23rd of January 2023 that they would apply for debarring any original expert evidence the claimant might file on the day designated for filing the supplementary expert reports. And if the court can look with us at Appendix D5 to Ziad Goma's witness statement, so it's Exhibit D5 in the bundle. This would be page 77. So it will be 00877.
Okay.
All right. So in that email from the defendants, the defendants informed the claimants that they will apply to the court to debar any evidence that they might submit as original reports on the date of the supplementary reports. But what happened is the claimant did not directly file its new expert evidence on the designated date for the supplementary expert reports. Instead, it filed its application number 2, CFIC 077-2022/2, requesting the extension of time for the filing of the supplementary report. This is in order to circumvent the defendants from applying for sanctioning the claimants from breaching the directions of the CMC order. This is why the defendants contend that the claimant's request for extension of time is only a disguised attempt to legitimize its breach of the directions of the CMC order. Therefore, the defendants contend that the claimant should not again be rewarded for deliberately breaching the directions of the CMC order. Finally, the defendants' submissions are requesting that the court would deny the claimant's application number CFI 077-2021/2 for the extension of time designated originally for the filing of the party's supplementary expert reports, and to sanction the claimant pursuant to Article 26.82 of the DIC Court Rules by barring the joint expert report it filed on the 9th of February 2023 from the evidence in this case, and of course an order for the claimant to pay the costs of the defendants.
Thank you, Mr. Uma. Claimant's position?
Thank you. Good morning, Your Excellency. The claimant opposes the defendant's application. I wonder, Your Excellency, if I could begin by starting with the case management order, which was made on the 28th of October of 2022, and that can be found at page 008-2 of the bundle. That's the first page of the order.
Mm-hmm.
I'd like to go straight to paragraph 26 of the order, which is on page 0085. And paragraph 26 makes very clear that the parties shall have liberty to apply, which in my submission, and which indeed is a standard part of any case management order, that the court envisages that there may be a requirement for the order to be changed as time progresses and as events occur prior to any particular trial. In this case, the claimant, in due course, as has been explained by Mr. Gomer and set out in the skeleton arguments, the claimant made an application to the court on the 27th of January of this year, and that is the application at D4 of the bundle, which starts at page 00849. And the application states at page 00850, the application states that the claimant seeks an extension of the time limit for filing and serving expert reports from the 2nd of February and to the 16th of February. That application was made as a result of the failure between the parties to agree an extension without the requirement to trouble the court. And as Mr. Gomer has pointed out, this commenced at page 00875, which is the email from Mr. Dedels of the 5th of January 2023, making it clear that there would be no expert report filed by the claimant on the 5th of January. But as he says in his email, the claimant reserves the right to file its responsive report in response to the defendant's expert report on the 2nd of February, as envisaged by the procedural timetable. If we go back briefly to the procedural timetable, which is the case management order, and to paragraph 15, which is on page 008-4. This is paragraph 15, which Mr. Gomer has already drawn our attention to. Paragraph 15 states that if party-appointed experts are engaged, then the parties shall file and serve their expert reports, if any, not later than 4 p.m. on 5th of January, and supplemental expert reports, if any, shall be filed and served not later than 4 o'clock on the 2nd of February 2023. The claimant's position is that it was not in a position to file an expert report due to the lack of evidence provided by the pleadings, provided in the defendant's pleadings, and therefore required to see what was in any expert report from the defendants. In addition to that, and I should say, Your Excellency, that that point is also made in the claimant's own expert report, Grant Thornton's report, which is the joint expert report dated the 9th of February 2023, which the court gave permission for the claimant to file. Paragraph 1.6 of that report, which is page 008-122, Your Excellency will note that in the introduction section to the report, Grant Thornton say, we were initially approached by EKP Legal, the claimant's legal representatives, to provide an initial report and supplementary report. But after reviewing the pleadings, we discussed the merits of this with EKP. It was our opinion that there was insufficient evidence provided in the pleadings for us to provide a meaningful expert opinion on the defendant's losses. It was agreed instead we would provide a responsive report on the defendant's expert opinion, as this would include a basis for the defendant's losses. And in addition to that, I wonder if I may, Your Excellency, make very brief reference to the document which preceded the case management conference. And this is the document which is not in the current bundle, but there will be no dispute in relation to this. This is the case management information sheet, which was lodged in court prior to the case management conference. And if I may be allowed simply to make reference to one question, which is the question on what issues may expert evidence be required. And this is under, it would appear on about the third page. It states then that property expert to opine on the loss of rental income and overpaid purchase price amounts claims, and then underneath that, accounting expert to opine on the value of the damages suffered by the defendants pleaded for in their counterclaims, only their counterclaims. The actual expert report, which was received on the 5th of January, contained material relating to the entirety of the claimant's claim, and also, as the claimants made clear, material relating to the property market. Now that, Your Excellency, simply puts into context the reason why, and if I may go back to the application notice of the 27th of January 2023, again, for everybody's benefit, that's page 008-50. This, or what I've just said, provided the background for the application that was made on the 27th of January by the claimant. That application was accompanied by a witness statement of Artur Dedels, the legal representative of the claimant. And that statement, his first witness statement, is at D3 of the bundle. And that starts at page 008-46. I don't tend to go through in detail the statement because everybody will have had an opportunity to read it. But I wonder if I might simply make reference in particular to paragraphs 6, 7, and 8 of Mr. Diddle's witness statement, where he sets out in detail why the claimant requires to make the application that it has made on the 27th of January, and that the application includes reference to the fact that the claimant now is in a position to both know what the numerical evidence of the defendants is, and also requires to answer the material that it has been confronted with, but an extension is required because there is evidence relating to the property market. That's section C of the defendant's report, which relates to rental income. And so for those reasons, the court was asked to grant an extension. Now, importantly, Your Excellency, the defendants, and no less than Mr. Goma, who has appeared this morning, the defendants were, of course, invited to produce any evidence from in objection to the application. Now, as is common ground, the defendants asked for an oral hearing. The court determined that an oral hearing was not required. The defendants were fully entitled to ask for an oral hearing, notwithstanding the fact that the claimant had said one wasn't required, and notwithstanding the fact that the claimant was unable with the defendant to agree an extension without troubling the court. The defendants, in the form of a witness statement from Mr. Goma, dated the 31st of January 2023, which starts at page 008-53, the defendants, in a lengthy 7-page witness statement, set out in detail why it was that the claimant's application seeking an extension of time should be refused. And that witness statement was accompanied by a number of appendices referred to in the witness statement, setting out the defendant's detailed opposition. That opposition was then sent to the court. And this is prior to the 2nd of February of 2023. And on the 2nd of February 2023, if I could ask Your Excellency to refer to the order that was made, which we'll find at page 008-103, the order of His Excellency, Your Excellency, makes clear, if I may refer to two things. Firstly, that it refers firstly to the case management order of the 28th of October 2022, which we've already looked at. And it makes clear that it regards the application as related to that and states that upon reviewing the claimant's application dated the 27th of January 2023, which we've looked at a few momentarily ago, seeking an extension of time of 2 weeks to file and serve expert reports by the 16th of February 2023, the extension of time application, and upon reviewing the defendant's evidence in answer to the extension of time application dated 31st of January 2023, which of course was Mr. Goma's 7-page witness statement with appendices, upon reviewing the claimant's evidence in reply dated the 1st of February 2023, and also reviewing the documents recorded in the court file, which will no doubt have included the case management summary and information sheet. If we look over the page at page 104, orders that the extension of time application is granted, and secondly, that it is granted for the claimant to file and serve expert reports pursuant to paragraph 15 of the CMC order to be extended by 1 week to the 9th of February 2023. So that's 1 week from the 2nd of February. And if we look very briefly at page 008-4, which is part of the original case management order, and to the reference to paragraph 15, it's clear, Your Excellency, that what the court was ordering was that the claimant was entitled to produce a supplemental expert report instead of this on the 2nd of February, on the 9th of February. So a 1 week extension was granted. And the reason for that, in my submission, was on the basis of Mr. Dadale's witness statement setting out why an extension was required. And if we go back briefly to page 103, that's the actual order, it's clear in my submission that this order was made with the case management order in mind. And this was an example, in my submission, of the claimant exercising its liberty to apply for a change of the case management order, which, of course, as we looked at the very start of my submissions, is at paragraph 26 of the case management order, which is page 0085. So in my submission, in summary, the claimant did exactly as it was entitled to do. There was no irregularity whatsoever about the application that was made on the 27th of January. It was fully entitled to make the application. It was fully entitled to seek the right to ask for an additional week for the serving of its supplemental witness statement. And in my submission, there was no requirement for a first expert witness statement to be produced before a supplemental statement to be produced. And in any event, Your Excellency, the court considered all of these matters and made a decision on the 2nd of February, Your Excellency making the decision, and that indeed at page 008, 105 and 106, not only does the court obviously make the order, but the court sets out a detailed schedule of reasons for awarding the claimant this additional week. It is very clear the basis upon which, and in particular, if we look at paragraph 7 of the schedule of reasons at page 106, Your Excellency notes that given that the defendant's expert report was filed on the 5th of January 2023 and the claimant filed extension of time on the 27th of January, I've granted the claimant's request to extend time and file and serve expert reports by 1 week rather than 2 as originally requested, mainly due to the fact that the claimant had been aware since the 5th of January. So it's quite clear that Your Excellency considered in detail the entirety of this application and all the associated documents and made the decision that was made. Thereafter, of course, the claimant then filed its expert report on the 9th of February within the time frame allowed and that is the expert report filed by Grant Thornton, produced by Grant Thornton, which has been lodged in for this hearing at page 008119. And therefore, in my submission, Your Excellency, the court has already considered not only the application for an extension of time, but fundamentally has considered the defendant's opposition to it, which was detailed in its extent, and was in writing. And in my submission, as we pointed out in the skeleton argument for the claimant, which starts at page 008232 of the bundle, as we set out at paragraph 10, the key thing here is that the decision as to whether or not to hold an oral hearing or not doesn't rest with the parties in any application, but it rests with the court. And there is provision for that in the rules, Rule 2369(3), as we set out, which states that the court may deal with an application without a hearing if the court does not consider that a hearing would be appropriate. And this is exactly what the court did in this case. And therefore, to suggest, Your Excellency, that in any way the claimant has done something irregular is, in my submission, wholly and utterly without foundation. And indeed, the court itself on the 2nd of February was quite satisfied that the claimant was entitled to make the application on the back of the case management order. It considered the opposition and granted an extension of 1 week, which the claimant complied with, and the expert report was filed, as I said a few moments ago, on the 9th of February. Turning to the position in relation to the defendants, Your Excellency, the defendants' position appears to can be summarised on the basis that they feel in some way that they have been disadvantaged or somehow been treated unfairly for two reasons. One, on the basis that there has been no oral hearing, and in my submission, as we have said in our skeleton argument at paragraph 19, which is page 008236, it is difficult in my submission to understand what different order the court might have made if there had been an oral submission, oral hearing, and also what submissions the defendants would have made that would have been different to the signed and filed evidence that was submitted in opposition to the hearing. It was a detailed opposition which was clearly considered by the court. And therefore, my submission, it is difficult to understand how in any way the defendants have been disadvantaged. So that's the first general ground for today's hearing from the defendants. The second one is that somehow there has been some procedural irregularity which has somehow caused considerable prejudice to the defendants moving forward. In my submission, that cannot be right, Your Excellency. The defendants have known since the 5th of January what the claimant's position is. The decision was made themselves by the defendants not to seek to have joint experts. They were probably entitled to do that in terms of paragraph 14 of the case management order. But the fact is that the claimant made clear what their position was. The claimant asked for an agreed extension. That was refused. The claimant had no option but to seek liberty to apply from the court. And they made it very clear why they were now seeking extra time. The claimant's application, it's important to perhaps make reference to, is this. It was not an application seeking permission per se to file a supplementary report on the back of the defendant's report. It was simply one asking for an extension of time. And the court took no issue with what the claimant was seeking to do. The defendants, in Your Excellency, have in no way been prejudiced. The trial is not fixed until the second week in May. If the defendants wish they too are at liberty to apply should they wish to seek the court's permission to file any additional evidence. That the liberty to apply is equally applicable to claimant and defendants in the case management order, and that the claimant fails to understand the purpose of this application. My submission, if I may, is that it is, as Your Excellency will be familiar with the expression, this matter is now res judicata. The court has determined the application. There has been no appeal to this determination. I accept that the defendants make clear why it is at this point a formal appeal has not been filed. And that is a matter for the court to consider. And indeed, we have set out at paragraph 16 of the skeleton argument, claimant skeleton argument, our understanding of the chronology from the 2nd of February until today's date, and that's at page 008 235. And so in my submission, there has been no prejudice. The trial is fixed for May. The timetable continues. The skeleton arguments and the chronology, etc., will be prepared, and that the claimant, the only change to the case management order, Your Excellency, is that if we go back to paragraph 15, which is at page 008-4, if we go back to paragraph 15, the only change is that the claimant was allowed 1 extra week to file expert evidence. Now, the defendants also say that this expert evidence was filed after the claimants had seen the defendant's expert report. That is correct. And as I indicated already, referring to paragraph 1.6 of the expert report, the claimant's expert report, and that is the commentary that's made at page 08122 by Grant Thornton, the claimant was not in a position to file a first report prior to the the defendant's report because of the lack of evidence in the pleadings. And no criticism is necessarily made of the defendants, but the only point is that it was only at that point that they could answer it. And as I said a few minutes ago, if the defendants have any issue with Grant Thornton's report, they too are at liberty to apply to the court should they wish to in any way change the timetabling and the directions that have been issued. So that in my submission, Your Excellency, there has been no irregularity. The defendant's application is in effect seeking a reconsideration of what has already been considered. It appeared initially it was simply asking for an oral hearing, and it now seems to focus more fundamentally on a reconsideration of the decision on the basis that there has been a procedural irregularity which has disadvantaged and prejudiced the defendants, which for the reasons I have set out is simply and cannot be the case, Your Excellency. And therefore, if we go finally to what it is that the defendants seek from the court today, which is set out at the end of the defendant's skeleton argument, which is at page 008-231, so 008-231, and paragraph 60, which is the very final paragraph of the skeleton arguments from the defendants. The defendants request 3 things. 1, to deny the extension of time. As I've indicated in my submission, that has already been determined. The extension of time has been ordered, and indeed the report has been filed. It was filed over a month ago on the 9th of February The defendants have had plenty of time to consider their position on receipt of that report. Secondly, at 60.2, the defendants seek to sanction the court to sanction the claimant pursuant to Article 26.82 of the DLC court. If we look briefly at what that actually says, at 2682, that can be found in the hearing bundle at page 008-216. That states at 26.82, under the heading Failure to Comply with Case Management Directions, where a party at 2682 fails to comply with a direction given by the court, any other party may apply for an order that he must do so or for a sanction to be imposed on both of these. Your Excellency, the claimant has not failed to comply with the directions. The claimant has applied to the court quite properly for a variation of the directions, seeking an extension of 2 weeks. 1 week was thereafter granted. The claimant was fully entitled to do that in terms of the liberty to apply provisions, and so it cannot be said that, and there is no basis indeed for it to be said that there has been a failure to comply with any case management directions. This argument is wholly misconceived in my submission, and the court should have little trouble in dismissing this request, that it should consider that the claimant has breached Rule 26.82. And so the claimant would also invite the court to dismiss that request, along with dismissing the requests for refusing the extension, which of course has already been granted. And finally, in terms of costs, the claimant, as has been indicated in the skeleton argument, the claimant, in the event of it being successful in its opposition to this motion, the claimant would seek its costs of defending this application. Your Excellency, I wonder, just before I finish, if I might just check to see if there are any additional points that I may be asked just to raise with Your Excellency. I don't believe that there are. Thank you. Your Excellency, those would be my submissions on behalf of the claimant in relation to this opposition, which is renewed. I'm very much obliged.
Thank you. In relation to this application, the claimant filed an application for extension of time. In response to the application, the defendant was given an opportunity to file its evidence and answer, and then the claimant again to file the reply. The judge who issued the order granting the extension reviewed all parties' submissions, reviewed the case file. The request in the application was a request for a court order without a hearing. In this regard, although the defendant requested for a hearing, the judge who issued the order found that there is, since the submissions are similar to what will be discussed in the oral hearing, decided that there is no need for an oral hearing to decide extension of time applications. Therefore, the judge issued its order with reasons based on the evidence provided by both parties and the case file, the case management order, and any other submissions in relation to the extension of time. The claimant was granted extension of time, therefore the claimant was granted to file its expert report. Yeah, the court has granted the claimant to file its expert report. The defendant then filed an application on 17 February, in which the extension of time determined after the hearing, after hearing the parties' oral submissions. I find that this extension of time application was already granted, already decided by the courts. The right procedure the defendant should have followed is to file an appeal rather than filing an application. The defendant should have filed an appeal, appealing the decision of the judicial officer or the judge who decided the extension of time application and the grant of filing an expert report. In this case, I dismiss the defendant's application for an oral hearing to reconsider the matter. The defendant shall file an appeal by the time period as described in the rules of the DIFC courts. If it wishes to oppose the order of Judicial Officer Metha al-Shehri in relation to the extension of time and granting the filing of an expert report on 9 February 2023. So requesting an oral hearing for a matter that have been decided and the submissions, the oral submissions, which are similar to the submissions that were filed in the case file, similar to the written submissions that were filed in the case file, is just a duplicate with the judge hearing both parties orally. There is no difference between the oral submission and the written submission filed. So in this case, the defendant's application for an oral hearing to reconsider the extension of time and to reconsider the expert report is dismissed.
Thank you,
Now, in relation to costs, the defendant shall pay the costs of the claimant for this application to be assessed if not agreed by the registrar. Thank you, both parties.
Thank you, Your Excellency. Thank you.
Can we confirm that the appeal time runs from today's hearing, since it was logical to wait for a hearing until it's decided?
The defendant has a liberty to file an appeal, yeah?
Thank you.
Within the time frame from the date of today's order, oral order, it will be followed by a written order, but from today's date until as per the rules of the courts, which is 21 days.
Your Excellency, can I just clarify that that relates to the original decision that was made? So if we want, because obviously it was proportionate to request an oral hearing to deal with the matter, that was how it was viewed by the defendant. So obviously we don't want to be prejudiced by filing an appeal and then being told, well, you're out of a 21-day deadline. So can we just confirm that you're happy for that to be?
It's from today's date, yeah?
Your Excellency, I'm grateful. And in terms of costs, we haven't received any schedule of costs from the other side. Am I correct in understanding that those are to be by detailed assessment and not immediate assessment?
It would be, if it wasn't agreed, it would be assessed by the registrar. Yeah.
Very well.
Thank you.